Please dismiss.
Like,
My lord, I have asked for little accommodation. Item 26. No, I am not seeking adjournment.
Okay,
Item 26, it may kindly be taken at 2 p.m.
okay.
Obliged.
yeah, please, Lordship, with respect to item number 23,
Yes,
probably Lordship will not be like to take up the matter because on last occasion.
I cannot take it.
Lordship,
Leave this matter before some other bench. Without one of us, Rashid, my name, huh?
much.
May it please your lordship. I document similar pen, madam, document item number 17.
17,
1717. This matter also may not be taken by your lordship.
17. Yes,
This matter may not be taken by your lordship because the review bill was filed against your.
yes, okay. Leave this matter before, same order.
Same, madam.
Please, your Lordship. I beg to mention an item to call for an additional affidavit in item number 29. The contempt is
29.
29.
Yes, what about it?
We have filed an additional affidavit, kindly
Your father,
petitioner,
husband,
husband, right?
okay. So the child was not given to you?
Lordship,
The child was not given?
no, Lordship. So we have filed an additional affidavit. With that regard.
We'll take it up. I hope the respondents council is here.
Yes, please here.
I hope your client is here.
No, she is not here today.
We are sending her to the jail. Today we'll pass the order.
Your Lordship, her child was hospitalized that day itself.
No, we're sending her anyway. The husband will look after. Tell her to come. We'll take it up at 2. Tell her to come here. We are going to call the police and we're taking her straight from here. And you give me all the details of where she is.
Yes. Malad, I beg to mention item number 78 of hearing list, man. Here, whatever, Malad, this, here in these appellants are
78
in,
of hearing list?
yes, Malad.
No, hearing list is not before us.
Special, regarding special bench.
No, there's no hearing list.
I am not praying for today's hearing.
There is no hearing list before special.
Special division,
I have not heard of a hearing list.
criminal.
list
There's no hearing list. What hearing list? Where
Hearing
have you
list
seen?
is published, Malad, subsequently it is
No,
coming
no,
up
sorry.
in special DB, Malad.
Maybe I have not seen it. I am sitting in the special DB. I don't know about it. How come you only know about it?
Hello, I beg to mention item number 28, madam.
28.
28, supplementary list, madam. Here I need some time to file our affidavit, madam.
Who's for the other side? Mr. Buya.
Yes, madam.
Yes, Lordship, I am appearing.
Okay, so he wants some time.
Lordship, there are some urgency.
It's a simple matter.
Yes, madam. Regarding, they have challenged the virus of the rule, madam.
You see, it's a simple thing. You have changed the rules.
Yes.
That's all. He says that the honors is required in that assemblies. And you say that it's no more required. That's all.
Yes, madam. I need 10 days time, madam.
I will give you a week.
Yes, madam.
Right. Mr. N.J. Khataniar, Learned Counsel for the which department?
Secondary education.
Secondary Education Department. Appraised for a week's time to file affidavit in terms of the earlier orders passed by. Prayer is allowed. List the matter on given.
Obliged, Lordship.
Hey, please, Your Honor. Lordship, I beg to mention item number 20 and 21, Lordship. I already have obtained consent from the other side, Lordship.
Miss Bhattacharya, Learned Counsel
I'm for the respondent number, state respondent, Lordship.
for the state respondent. Praise for adjournment. As the same is not objected to by
After vacation, madam.
the counsel for the petitioners, list the matter
After vacation.
after vacation.
Before puja vacation, my lord.
List the matter. Is any objection?
No, Lordship,
The matter after vacation.
deeply obliged now.
May it please your lordship. 14 or 15, my lord. Yes. May it please your lordship.
My lord, in
Okay, give a date, 14 or 15. 15 of.
My lord, item number 13 and 14, my lord, both are connected matters. I appear for item number 13. And my learned friend is also item number 14, my lord. We are for the petitioner. My lord, there is some accommodation is needed, my lord, for today, my lord, in item number 13. He has not objected.
Okay. For the petitioner.
Petitioner, my lord.
And your father?
Petitioner.
I'm also heard about it, petitioner, my lord.
Item
Okay.
14.
Yeah, item 14 and in item 15.
I'm in item 13. sir.
What about Nagaland?
My lord,
State of Nagaland,
Yeah,
they have got to file the affidavit.
yes, my lord, this is the 4th day they are, I think,
But then you have asked for adjournment.
because there is some difficulty, my lord, to
Okay, right.
after a week, my lord.
On the prayer for adjournment made by Mr.
K. Mohammed.
K. Mohammed, learned counsel for the petitioner
My
in
lord.
PIL 22 of 2025. And Mr.
Is this Sharma, my lord?
A.J. Sharma, learned counsel for the petitioner in PIL 29 of 2025. The matter is adjourned for a week. List the matter after a week.
Deeply obliged. My pleasure. Also, with the consent of other side, I beg to mention item number 25. sir. The matter will be taken after 1 week.
On the prayer for adjournment made by Mr.
A. Dhanukar. For the respondents. Beg.
A. Dhanukar for the respondent PNB.
Lordships.
For the respondent PNB. List the matter after
1 week. lord.
a week.
May I please, your lordship, I beg to mention for listing of a criminal appeal for orders column, my lord.
When?
Next week, my lord.
Much obliged. May it please your lordship. With the consent of the other side, I beg to mention item number 5 and 6, your lordship. Your lordship, 5 is the offshoot of the item number 6, your lordship. In item number 5, we'll file our wakalatnama today. So may I please be taken up next week, your lordship?
Lordship, kindly fix the matter by next week, Lordship.
You are for appearing for whom?
I'm appearing for the private respondent number 7, your lordship.
7.
Yes, your lordship.
Just a minute. Let it come.
Yes, sir.
In a hurry. Let it come.
That's because item number 22, probably your lordship may not like to take up this matter. My lord Justice K. Goswami was the counsel, was an amicus in the matter, my lord, earlier.
Huh?
My lord Justice K. Goswami was an amicus.
Oh, he was in the mic. Okay. You're not going to be here. You will be here.
I'll leave it to your lordships.
Okay, we'll list it on Friday. We'll list it next week.
Before.
4th.
Right.
Okay, right. List this matter. In some other bench without one of us. Justice Goswami, okay? List the matter on 4th.
Other side was informed, he has no objections.
Okay. But if there is an eyewitness, the daughter is there.
We have a good case, I think so.
I think so. He also confessed
Yes,
to that PW.
extrajudicial confession before the Gao Burhan.
The daughter is there.
Yes.
That's- if they will pick it. Isn't it?
May please, your lordship. My lord, this contempt petition for non-compliance of order of this.
The contempt. Let us see. Where is the contempt? Where is the contempt?
My lord, it is their own submission that the scheme is adopted and that will be implemented. Lordship will find in the paragraph page 11, my lord. It is their own submission that the project would be implemented by maintaining the time-bound limit and standard. And they have nothing has been noticed to work about the groundwork, my lord.
Is that they're going to address the issue, that's all. Where's the contempt? Where's the direction? Where is the violation of this court's order?
My lord, it is their submission that they will implement the scheme. They have done nothing, my lord. They have not, nothing has been done, my lord.
You file another case. Where is the violation? Where is, what direction has this court passed? What direction has this court passed? Which order has been violated?
My lord, my lord.
It is only a
that-
submission. They
That
said
is
that
their
they will-
submission, my lord.
So where is the contempt? What do you understand by contempt?
My lord, they have submitted before the court that you will do these things.
You file.
But they have done nothing, my lord. Is it not a contempt, my lord?
You tell me what is the, show me the law of contempt. Huh? There's no contempt.
My lord,
You file a separate.
my lord, it is their submission that they will do these things. They have done, they have submitted before the court and court has been given false assurance that they will do things. Is it not a contempt, my lord?
No, not now. It's not a contempt.
Where is the direction, Mr. Counsel? There has to be a direction. You have agreed to the submission made that at this stage, that paragraph, read that paragraph.
Read it.
My lord, yes, my lord.
11.
In the paragraph 11, my lord. Mr. R.M. Das, Learned Counsel, appearing for the Water Resource Department, the respondent number 6, 7 and 8 has submitted that the modified DPR from the project authority is already received and the same has been sent to the chief engineer BDO CWC for further action. Mr. Chaudhary and Mr. Das have submitted that the project undertaken by the respondent will hopefully tackle the problem of erosion in the Bohuri to Babbar. It is also submitted that the project would be implemented by maintaining the time limit and standards.
Now
What is
read
the-
They have submitted before the court.
next, at this stage,
At this stage, the Learned Counsel for the petition has submitted that the efforts carried out by the respondent to tackle the problems highlighted in the PIL petition are being addressed in a proper manner. This is also, my lord, misleading, my lord. They have done nothing.
This is learned counsel for the petitioner, it is you.
No, my lord.
What do you mean no? Learned petitioner means respondent or what?
But they have done nothing, my lord. That is it.
File a separate case, not the contempt. Contempt does not lie. You want, it depends upon you. If you go to Supreme Court, we're taking care of this order.
No, my lord, we will
You file a separate case, that's better.
separate petition, my lord. Yes.
Mr. A.R. Sikdar, learned counsel for the
We may be
petition,
allowed to do it and file a
submits that he may be allowed to withdraw the writ petition. That the contempt petition to enable the petitioners to submit an appropriate petition. The prayer of the petitioner's counsel is allowed. The contempt petition stands closed with liberty
Leave
and spirit.
And 2 and 3 almost same. Lordship, this is a petition against the order of cat lordship without.
What is wrong?
What is wrong, my lord, without giving us an opportunity to reflect. Here, lordship petitioner number 2.
You come straight away.
Lordship.
I think you are represented on that day.
Represented, but we are not given chance to file our written.
You tell me what, you have allowed him
Lordship
to
on
participate.
not.
No objection
With
certificate.
regard to 2 and 3, we are only given NOC for document verification. Participation, they have not, kindly see lordship.
No, I don't think, you see, you have allowed him to participate in the examination. He has been selected. Who are
Lordship-
you to stop him?
We are not, kindly see our policy, lordship. In
Let us see a policy page.
lordship. Page 320, lordship.
320, yes.
Down. Lordship 2.1, railway.
Yes.
2.1, railway employees, whether permanent or temporary, may be given for opportunity to apply for the post in the government department, public sector undertaking, autonomous body, wholly or substantially financially controlled by the central or state government. However, the general manager, head of the department may withhold the application if they feel that in the public interest, it is not possible to release the railway servant concerned for the post outside the railways. Next page, lordship, while it is not feasible to define public interest, the authority should interpret the term
strictly and subject to the condition that forwarding of an application should be the rule rather than exception, and the decision should be taken at appropriate level. In taking the decision to withhold the application, the authority has to balance the interest of the state against the necessity of causing hardship to the individual. This discretion should be applied with utmost objectivity and not mechanically. While it is not feasible to lay down the specific exhaustive guidelines for withholding of application in public interest, some of them can be listed illustrative as follows. The officer concerned is engaged in important time-bound project and the work would be seriously distorted if he is relieved. Here, Lordship,
Now that is our 1991.
91.
Please come to page 318, 318. This is of 8/8/2025.
Lordship.
Please read.
It is seen the division are issuing NOC of their employees for railway transfer, own request transfer or apply against new another post in other central government, state government office vacancy for fresh selection. There is an acute shortage of staff category state at present on NFR.
Please carry on reading.
New lines and doubling are being added to NFR network every year without any addition input to the manpower. In view of the above, keeping the safety of the train passenger NFR, the NOC of the concerned employees shall issued only after getting approval from the headquarters.
Correct. Now this is
Lordship.
NOC should be issued only after getting approval from the headquarters. This is of 8 August 25.
Lordship.
When did you give the NOC?
Lordship for document.
Sorry, when?
January, in this case, Lordship, one of the NOC was given.
Huh?
February 20, February.
To August.
Prior to August.
Where is the question?
In fact, in a similar exact matter, basing on which this order was passed by the learned tribunal, that was challenged by the railway authorities before this honorable court, and this honorable court was pleased to dismiss the writ petition, my lord. Jagdeep
Our
Kumar.
contention is we have not given an opportunity to file our reply because here,
Mr.
Lordship.
You see, your only case is
Lordship. Acute shortage of staff is,
shortage.
yes, Lordship.
Why did you allow him to participate in the examination?
Kindly see his document, only for document, this two petitioner not applied for applying, they have not applied when they are applying for the post. They have only asked for document, kindly see his.
Clarify one thing, my lord. There was no examination held. My lord, the contention of my learned friend is wrong. My lord, what the Bihar Technical Service Commission has did, my lord, basing on the marks put in the diploma examination, in their JE examinations, they held a selection.
No, you are allowed to participate in the selection process.
Yes, my lord. So we are not.
Kindly see, Lordship, kindly see page number 81 of this petition, Lordship. This is the petitioner respondent number 1. No objection shall appear against the advertisement of subject was the reference your application NOC to appear in the document verification. He has not taken NOC for participating in the examination, Lordship. He is only for in 2025 for document verification, Lordship.
Mr. Counsel, for document verification for what? Just for show?
Lordship.
What is this advertisement for? This advertisement of 8/3/2019 is for what purpose? Is to show your face or for recruitment to a job?
Only thing, Lordship,
it is for recruitment to a job. So you have allowed him to participate and you have allowed him to submit his documents for that purpose.
And now, Lordship.
Now he has been selected. So you cannot stop him this level.
Now, Lordship.
Nothing, and there's a covered matter. Similar. Have you read this order?
Seen, Lordship, here, Lordship, we have filed our WS, Lordship, but
look, it's the same thing out here. The facts are exactly similar. Only thing out here, you have not submitted your written objection or your affidavit, whatever.
Lordship.
That's the only thing.
Lordship.
And another thing, you were represented before the your counsel was there. Where is did he ask that he should submit a affidavit?
Lordship, that
did he ask for submit?
obvious, Lordship, it
Huh?
was not reflected in the order, Lordship.
It was
but
not
it is
reflected, but he asked. Is that,
He
is that your
asked,
case?
Lordship.
Then where is the averment that he asked for time to file an affidavit, but he was not granted? Where is that in your?
Only ground, Lordship, that we have not given an opportunity. We have taken the ground, Lordship.
You can go to Supreme Court, you can always take the same ground there.
Lordship, on that, Lordship, similar coordinate bench, Lordship, has passed an order, Lordship, for filing written statement
No, huh?
to give an opportunity, Lordship.
I'm giving opportunity, but when there's nothing here. This is Wipro side here, went through But what was the context of this case?
This was suspension, Lordship. On the first day, Lordship was dismissed, allowed the petition, Lordship.
Okay. At least not to ask, not. In this matter, then you've got no plea. Right. Did he ask for time? There's nothing, no? There is nothing. There is nothing in your pleadings. It's not in your pleadings that you had asked for time before the tribunal. Have you made such an averment?
Lordship, on the ground, we have not, we have taken the,
Then how can you make that then?
at the, without,
Ask, if you did not ask,
we have asked, Lordship,
no. Have you written? Is it there in black and white? In
Lordship, for the, Lordship, ground A, Lordship, admission stage videos and notice and calling for any reply from the petitioner here in the view of the facts. and-
That is just a averment. Not backed up. Exactly. No, and nice try. Maybe you can go to, you have another avenue.
Yeah.
Still there. Heard Mr. SSO. Learned CGC. Appearing for the writ petitioner. Also heard Mr. Das. H.K. Das, learned counsel for
120.
123. 123?
Respondent number
Respondent
123. Acha, you have challenged three cases there.
One
Similar.
common order has been passed.
One common order has been passed.
Yes.
Right. The petitioner's case is that the Central Administrative Tribunal, Guwahati Bench, Guwahati, had disposed of original application numbers 040/173/2025 bracket Shri Om Prakash Ranjan versus Union of India and others, comma. Original application number 040/171 of 2025 bracket Shri Pramod Kumar Tanti versus Union of India and others, bracket close. And original application number 040/192/2025 Shri Bimalesh Kumar Bimal versus Union of India and others, by common judgment and order dated 23/7/2025, comma, directing the writ petitioners to relieve the respondent, the private respondent, by accepting their technical resignations with a condition that the respondents will not retain any lien over the post held by them. Once they join as JE bracket civil slash mechanical slash electrical in under the government of Bihar. The petitioner's case is that the above three original applications were disposed of by the learned tribunal at the admission stage without issuing any notice. That is his case. Without issuing any notice and without allowing the writ petitioner to file any affidavit. Correct? That's your case. Next paragraph. The counsel for the respondents number 1, 2, and 3, on the other hand, submits that the petitioners, that the respondents who are working as junior engineers, bracket civil slash mechanical slash electrical, under the writ petitioner, were given no objection certificate, bracket NOCs, to apply for the post of junior engineer, bracket works, is it? Junior engineer?
Yes.
Works.
Junior engineer, Lordship will write junior Indian engineer stroke senior section engineer.
Junior engineer slash senior section
Section
engineer under the government of Bihar pursuant to advertisement dated
It was
Advertisement is dated, my lord.
in 1 of 2019.
that
Yes, it's there, my lord. I'll just play. 8/3/2019, my lord.
all of them 8/3/2000.
All of-
3/2009. The petitioners, the private respondents were thereafter selected for the post of junior engineer slash section assistant engineer.
My lord,
Junior engineer oblique.
I'm sorry. Junior engineer plus SSC is in railway.
I'm talking about Bihar.
Bihar, my lord, only junior engineer.
That's for junior engineer.
I'm sorry. Junior engineer civil,
Junior engineer civil. Junior engineer civil only,
civil.
not mechanical and.
No, nothing else.
Junior engineer civil, huh? Junior engineer civil. What have I said? Last sentence. Civil under the government of Bihar pursuant to the advertisement dated so and so. On their being selected, the respondents submitted they have submitted their applications for being granted technical for accepting their technical resignations to enable them to join the new post of JE Civil, Mechanical, Electrical in the government of Bihar. However, as the respondents had allowed, as the writ petitioners had allowed the private respondents to participate in the selection process for recruitment to the post of junior engineers, the writ petitioners could not now withhold their applications tendering the technical resignation. The learned counsel for the learned counsel for the private respondent also submits that in a similar matter, that is WPC 4425/2025, bracket Union of India and 6 others versus Jagdev Kumar, which was decided on 18/8/2025. The writ petitioners were directed to oh no, what do I say? No, this court directed. This court had justified the direction passed by the learned tribunal, directing the writ petitioners to accept the technical resignation of the respondent therein on the same ground. We have heard the learned cause for the fact. As can be seen from the government, can be seen from the documents on record, the private respondents who were working as junior engineers
Junior engineer,
in the
junior engineer stroke, senior section engineer,
junior engineers / senior section assist engineers
senior section.
under the NF Railway
Yes.
had applied for grant of NOC to participate in the selection process for recruitment to the post of junior engineer bracket civil mechanical.
Only civil, not.
No. Civil.
No.
It's there, my lord.
The civil mechanical / electrical under the government of Bihar. The same had been granted by the petitioner to the private respondent, and accordingly, the private respondents participated in the selection process. The private respondents were thereafter selected for appointment as junior engineers, civil, mechanical, electrical in the government of Bihar. The private respondents thereafter tendered the technical resignations from the writ petitioner to enable them to join their new posts under the government of Bihar. However, the writ petitioners declined to accept the technical resignations of the private respondent on the ground that due to paucity of officers in the NF Railway, it was not possible for the railway administration to release the respondents from their current post. Further, in terms of the letter dated 15/7/1991 issued by the Joint Director, Establishment bracket N, Railway Board, to the General Managers, All India Railways, the General Managers / Head of Department were given the power to withhold applications from their officers who sought opportunities for being recruited outside NF rating. Next part. We have noticed letter number W/PC/MIS/T.11 Roman 2 8825 page 318 issued by the principal chief engineer to the Northeast Frontier Railway, which states that in view of acute shortage of safety category staff in the NFR, the NOC of employees who seek to participate in a selection process in other state governments, central government, etc. The NOC of the concerned employee shall be issued only after getting approval from the headquarters of. In the present case, the NOC to the private respondents had been issued much prior to the letter dated 8/8/2020. As such, when the NOC has been issued to the private respondents to participate in the selection process for recruitment to the post of JE in the under the government of Bihar, there was no justification for the writ petitioners to withhold the technical resignations rendered by them on being selected for the set. Next part. We have also noticed that in the impugned judgment and order dated dated
23/7.
23/7/2025 issued by the learned tribunal. The writ petitioner was represented. And there is nothing in the impugned order to show that he had asked for any time to file an affidavit. In any event, the issue raised hearing by the writ petition would have been the same stand taken by the before the learned tribunal. In the writ petition, no averment has been made by the writ petitioner to the effect that the counsel for the writ petitioner had asked for time to file an affidavit before the learned tribunal. As such, the stand of the writ petitioner that that they should have been given time to file an affidavit on the same issue, on the same points that have been stated herein. That's no eyes with us. And the same cannot be said to have caused any prejudice to them. Next paragraph. In the case of WPC 4425/2025, Union of India, 6 others versus Jaldeep Kumar. The respondent who was a junior engineer with the NF Railway had been allowed to participate in a selection process for recruitment to the post of JE Civil under the government of Bihar. What have I said? Comma, by way of an NOC issued by the NF Railway. On being selected for appointment as a junior engineer under the government of Bihar, comma, the respondent had submitted an application to accept an application to the NF Railway to accept his technical resignation. However, the same had been declined on the ground that there was paucity of officers in the NF Railway. The respondent had approached the learned Central Administrative Tribunal, Guwahati, for a direction to be issued to the NF Railway to accept the technical resignation tendered by the respondent. The learned tribunal had allowed the same and a challenge was made through the direction passed by the learned tribunal in WPC 4425/2025 by the Union of India. However, this court, by order dated 18/8/2025, dismiss WPC 4425 of 2025 by holding as follows, para 8. Para 8. Para 8 and 9. Para 8, 9 and 10. Para 8, 9. On considering that the facts of this case and the facts in WPC 4425 of 2025 are similar, we do not find any ground to interfere with the impugned judgment and order passed by the learned tribunal in OA numbers 173/2025, 171/2025, and 192/2025. The writ petition is accordingly dismissed. It is however made clear that as and when the private respondents assume their post of junior engineer.
It's already there in GATT order.
It is already there.
It's already there.
Cut that. No need.
It's not required. Make case is also.
Only order dated 27 June 2024.
Okay, out there, date of, what is the date of?
27 June.
June.
Okay, out here it will be OA number
Yes.
OA 040/00146/2025, page 85, page 81. And the date of the order is, judgment order is,
OA will be 195 or 25.
194/2025 only. Page 92.
One 195. OA number, page 85, Lordship.
OA, is it, which one is it?
Santosh.
Okay. I think page 92, right?
Lordship, 85 is,
Acha. Okay, it is this one. No, it is actually 040/194/2025.
Exactly.
Page 90.
Page 92.
Page 92, huh? 040/194/2025. Dated 27/6/2020.
Yes, my lordship.
Okay. So out here, what was he? He was JE in the railways.
Yes,
JE what? Civil.
yes, my lord, J civil.
Civil, yeah, JE Civil in the railways. And so he again for JE in the JE Civil in the government of Bihar. One respondent only, huh? Private respondent.
JE, my lord, J civil stroke SSC, my lord. I'm sorry, my lord.
All right.
Highly.
May it please your lordships, in this present matter, the petitioners have been granted the status of temporary Mazdoors under the with effect from 1996, my lord, in terms of the order of the Guwahati High Court dated 15th of June 2017, which is an annexure I, your lordship. However, at that time, once this order of the High Court was passed, the responding authorities did not comply with the said order. Therefore, the petitioners approached this court again by way of a contempt petition. Now, at that time, when the contempt petition was going on, it is at that time that notification dated 28th of July 23, which is an annexure K, was issued, granting temporary status to the petitioners with effect from 1996. In the meantime, my lord, before the contempt petition was closed, they issued an impugned order dated 12th October 23, whereby the condition number 3E was changed, my lord. That is
But
an
the
annexure.
BSNL as such is not a pensionable establishment. So there was an error in the earlier order that they would be covered under ZPF. Only to that extent, my lord, the correspondence was issued. And therefore, they were brought under the EPF.
So, should you file an affidavit or what? Or is it an appeal?
My lord, it has come from the tribunal.
Come from the tribunal. And what did the tribunal say?
The tribunal turned down, my lord.
Lordship, that is why the petitioners had approached the Honorable High Court. Initially, actually, in 2006, they were granted the TCM status, my lord. But then, because an impugned order was issued in 1997
No, you see, basically you are aggrieved with
by
the
the
corrigendum
Collegium. Yes, madam.
of 23.
Yes, madam.
Okay, against the notification issued in 23 itself.
With
One is
effect
of
from
August,
1993.
one is of July and one is of October.
Yes, madam.
So the October corrigendum has made amendment of 3E,
Yes, madam.
correct?
Yes, madam.
So we have to see that. So prior to 23 July, this is not the issue at all.
Lordship, Lordship, in 1996, they were granted the status because of an erroneous order. It was removed. Therefore, they had approached this honorable court again. They had approached CAT. CAT had dismissed it. Therefore, they came back here, your lordship. If my lord peruses annexure K, the temporary.
Why haven't you challenged this corrigendum before CAT?
Lordship, because all the other issues have already been dealt with. When the contempt petition was pending.
Still, what about this? What about this 28 July 23? Why have you not have you got this notice to CAT? Got this to the notice of CAT? Has CAT decided the issue regarding this 28 July 23 and this corrigendum of 12th October 23? Has it decided this issue?
No, my lord. This
Then-
28th of July is
Why
result of the High
are
Court,
you
sir.
coming here?
Then
You challenge it there. Then you come here.
okay, your lordship.
You
That
cannot
is
come
still a-
directly to this place.
The
Correct.
only reason we came here, lordship, is because all the others, the issues were dealt with. Only
This issue has not been dealt with. You deal it there.
in that case, we'll approach CAT, my lord.
Yes, you withdraw this. Miss
S. Sharma Hazarika.
S. Sharma Hazarika, learned counsel for the petitioner, submits that the petitioners would like to withdraw the writ petition whereby a challenge has been made to the corrigendum dated 12/10/23 issued by the BSNL, which as amended the term and condition number Roman 3 bracket E of the letter dated 28/7/23 issued by BSNL. Mr. B. Pathak appears for
Respondent number 2 to 7.
Point number 2 to 7. That's fine. Good. The prayer of the counsel for the petition is allowed. The writ petition is dismissed as withdrawn with liberty of people.
Apply.
Yes, who's appearing for the private respondent?
Me,
Appearing for whom?
your lordship,
Seven law.
Jagat Deka, your lordship, respondent number 7.
But there are so many of them.
No, your lordship.
Respondent number 7.
Yes, he's the private respondent. He was the writ petitioner, the
Okay.
honorable single judge.
What about 8? 8 is
Your lordship,
Comma.
private respondent number 8, he has neither appeared in the writ petition nor he has appeared in any other matter before the division bench, your lordship.
so what do you want to do here?
Your lordship, this item number 5 is the offshoot of the item number 6. There were 10 appellants. So the appellant sought the leave of this court to file the separate appeal in respect of 5 appellants, appellant number 1 to 5. And therefore, this leave was granted and accordingly, this item number 5 was filed.
Is there a challenge to the rules or what?
No, your lordship, there is no challenge to the rule. your
So
lordship.
writ appeal, your lordship.
So this has come from a single bench.
Yes,
Single
your
bench.
lordship.
Yeah. So what do you want to do?
I'll file I'll enter appearance, your
You
lordship,
have not filed Vakalatnama.
in item number 5. Item number 6 I have filed, item number 5 I have.
So we can dispose of.
Yes, your lordship.
We have not completed, lordship, with the told us they've been seeking adjournment to their lordship. You mean the first
There
week of
is no
September?
question of filing any affidavit. Everything is here, I guess.
Yes, your lordship, everything is there, nothing. The only thing is that I have not filed my power, your lordship, in this
Okay, Mr.
R. Sinha.
R. Sinha submits that he will be appearing for the respondent number 7 and submits that he will be filing his Vakalatnama
Today itself.
within the course of the day. This is the matter.
On
Next week.
4th, your lordship. 4th of September.
This is the matter on 4th.
Yes, your lordship. Deeply applied.
I'm for the respondent. For the respondent wife. This money has to go to you.
Yes, sir.
Huh?
Yes.
I think this money.
We have served a copy of IN criminal appeal to the respondent number 2,
You
Lordship.
can hear. Yes,
Yes.
tell me.
Lordship, the matter may kindly come up on some other day, Lordship.
Why?
My senior Lordship, he is not, he has some certain difficulties, Lordship.
What difficulty? Who's the senior?
Mr. S. Borthakur. Lordship, 4th of September is fine.
Everyone wants 4th. We have put already 2 cases on 4th.
Lordship, one last chance, Lordship.
Fifth floor.
5th.
4th,
Oh, good luck fixes it.
5th.
5th, Lordship.
Okay, Mr.
US Bora.
U.S. Bora
Bora.
appearing on behalf of
Mr. S. Borthakur.
Mr. S. Bhattakur, learned counsel for the applicant. Prays that the matter may be taken up on 5th.
Lordship.
This is the matter on 5th.
Lordship.
I suggest the matter pertains to the applicant appellant being convicted under section 6 of the POCSO Act.
Obliged.
Okay, in the main case, you write, a registry prepare the paper book.
May it please, your lordship. Lord Dan. This IA is for suspension of sentence and bail, my lord. Here, the appellants were convicted under section 396 IPC.
Appellant 1 and 2.
Two, my lord, both appellant 1 and 2. They were convicted under section 396 IPC. The occurrence was of 1989.
What is 396? What is it?
396, it is dacoity and murder, my lord. dacoity with murder, 396 IPC. But here, case is, my lord, in the FIR, nobody was named. Some unknown miscreant entered and dacoity took place. And wife of PW2 succumbed to the injury.
Wife of PW2.
PW2. Now, my lord,
No eyewitness.
eyewitness court, learned trial court has presumed PW2 as eyewitness. PW2, the husband of the victim.
Why don't we decide the entire thing? Why only go half?
But
But you see, it'll amount to hearing the whole thing. There's nothing, we'll go
Get
through
it.
the entire evidence.
Lordship, kindly have a look at the FIR first.
FI is not the encyclopedia. PW2 is the eyewitness to the
I'm
offense.
coming to that.
Anyway,
I'm
let
coming
let
to
us, let
It is
we'll
submitted.
dispose of the entire
Coming to
thing.
that option.
Huh?
FIR, Lordship will get at page 3 of the paper. My lord.
Yes,
Page 3, there is FIR. I have honor to state that around 1:32 AM on 3/7/89, some miscreants armed with dagger and other weapons entered the house of my younger brother, Sri Sahadev Mandal, by breaking the wall of the house, assaulted him and thus caused grievous injury to him. They also caused grievous injury to his wife, Srimati Dandabala Mandal, by stabbing her in the stomach with a dagger. Now her condition is critical. They also assaulted Srimati Durgabala Mandal, the 3 or 4-year-old daughter of my younger brother. Later, the miscreants took the below mentioned articles away from the house. I therefore pray to you to investigate the matter and take necessary action. The articles taken away, rupees 1200 and one gold earring. This is the FIR. No one is named in the FIR. Now, my lord,
the date,
date is the intervening night of 3/7/1989 and 4/7/1989.
no, FIR date.
FIR was lodged on 4/7/1989, Lord.
4/7/99.
1989. In fact, it was occurrence was
And the occurrence was at 1:32 AM in the morning.
morning, Lord. 4/7 itself.
On 4/7,
4/7.
3/7.
The intervening night of 3/7 and 4/7, 1:30, it is exactly 4/7 or after 12. 3/7 will be different. It will be 4/7, in fact, Lord.
As per the FIR, 1:32 AM on 3/7, since 2 AM. up
When
to
will be
12,
4/7 actually?
4/7.
Yes, 3 to 4, yes.
It should be 4/7.
4.
Hindu calendar, once the sun rises.
Yes, then it is 3/7. But if you go by this Christian calendar, then 4/7.
So basically on 4/7 it happened, but mistakenly written as 3/7. Is it? This also on 3/7/89 cannot be. What is the
No, because it was, sun was not set, my lord.
89?
Yes,
98.
3/7/89.
1989.
89?
89, my lord.
Oh, 89.
1989. After 35 years, you know, they were convicted. They were all along on bail during this period.
Okay, let's go.
Then, my lord, the PW1.
So this charge has been framed only on 2012.
Yes, my lord. Because some were absconder, it was going on. Then district was bifurcated. From Bongaigaon, it has become Sirang. All these are
That's intervening night, intervening of 3/7/89 and 4/7/89. Okay.
so it would be 4/7.
Charge it as a four. Yes,
Then the PW one, that is at page 9 of the paper, my lord,
page 9.
page 9.
Yes,
He is the brother of the victim, PW two. Now, I know the two accused persons, Ranjit Rajwangshi and Shankar Rajwangshi. I know the other accused, so and so, so and so. Informant, Basi Mondal was my younger brother. He is no more. The incident took place around 2:30 a.m. on a Monday in the month of
Basi Mandal.
Bidu Basi Mondal. In fact, not in translation, it is written Basi Mondal.
So Basi Mandal was the.
Bidu Basi Mondal was the informant. The incident took place around 2:30 a.m. on a Monday in the month of Ahar, some 22 years ago. When my younger brother Sahadev Mandal screamed, I woke up and went to his house. Sahadev's house is about 1.5 bighas of land away from my house. Thira Burman's house is situated in between. Having heard the UN cry, I immediately went there. Going there, I saw my sister-in-law Dandabala Mandal, wife of my younger brother Sahadev Mandal, lying on the floor of the house with injuries in her stomach. Her intestinal matters were found protruding from her stomach. I found my younger brother Sahadev Mandal with injuries on his hand. I have forgotten which hand it was, stomach and back. I found 4-year-old Durga Mandal with bullet wound on the leg. I have forgotten the leg. The miscreants took earring of Dandabala Mandal and sum of rupees 1200. My younger brother Sahadev Mandal said that out of the group of miscreants consisting of 7-8 members, number 1, Shambhu Burman and Jiten Burman were present. He did not name the present appellant, Milord. Sahadev Mandal, who is presumed as eyewitness, PW2, he did not name the present appellants before his brother. Though he also told me the names of other accused persons, I have forgotten them.
So I have forgotten them. He might have named
Maybe.
them.
He might have forgotten. But I mean, Lordship, I have forgotten the name. Hearing the hue and cry, a lot of people, including Ramesh, so and so, they came. Now it was at the relevant time, the Bodo movement was prevalent in our locality, and the Bodo people taking part in that movement used to demand money. They used to shoot the people who could not pay. At that time, electricity was not available in our area, and in fact, it is not available even today. There are some 70-80 families in our village. When I went to the house of my younger brother, after hearing the hue and cry, I did not see the dacoits, miscreants, as they had already left. The villagers came after I had gone there. So he was the first person who went there. Thereafter, villagers came. The police did not show the accused persons present in the dock today. The police took my statement at about 7-8 a.m. The following day, I do not know when my brother lost the Azahar. The accused persons are my neighbors. I do not know if my younger brother had dispute with the accused persons regarding boundary land. Next, my lord, it is not a fact that my younger brothers recognized the accused persons and so he told me their names. So it is his direct evidence that it is not a fact that he recognized. PW2 did not recognize, my lord, the specific evidence of PW1. And he did not told their names.
I don't know whether translation is correct or not.
No, it is in the vernacular also. I can go to vernacular, same thing, vernacular also. In vernacular, he has stated.
So if he did not recognize them, how did he know their name?
Yes, my lord. So PW2, who is presumed as eyewitness, he did not recognize the miscreants. It is the evidence of PW1. Now, my lord.
Let us see how does he know this? We have to see what PW2 says.
Yes, I am coming to that, my lord. Next is PW2, my lord, at page 12. Let me come to cross of the PW2. That is at page 13.
Read the very beginning.
Okay.
Why you want to?
Sure. I know the accused persons. The informant Bidubasi Mondal was my elder brother, and that he breathed his last about 17-18 years ago from today. on the night intervening 3789 and 4789 at about 1 a.m., the occurrence took place. Initially, some miscreants kicked on the walls of my residential house and that they knocked on the door of my residential house too. However, I opened the door even though I apprehended danger. He knew there is danger, but he opened the door. On opening the door, the accused Shankar Rajvanshi, Ishwar Rajvanshi, Ranjit Rajvanshi, Gyanendra Namodas, Jiten Rajvanshi, Major Rajvanshi, who were co-villagers, entered my residence. I could see that accused Shankar Rajvanshi, Ishwar Rajvanshi were armed with guns and that others were armed with daggers. I could see them in the light of hurricane lamp that was lighted inside our residential house. I was caught hold of by the accused Shankar Rajvanshi, Ranjit Rajvanshi. I swear Ishwar Rajvanshi, they inflicted dagger blows on the stomach and on my back. On being put resistance by me, the dagger also inflicted cut injuries on my hands. Requesting not to harm any further, myself and my wife handed over her earrings from her ear, cash amount of rupees 1200 that was kept under my pillow. Myself also handed over my golden ring that to the accused that was put on my finger. Request of my wife, Srimati Dandabala Mandal, not to perpetrate torture anymore were turned down by the accused, who put kicks on her at once. Standing in such merciless condition, I put resistance against the accused persons and I pulled out the dagger from the possession of accused Ranjit Rajvanshi, and that I dealt a dagger blow on the head of the accused Ranjit Rajvanshi. In such a moment, the accused persons made a free. Soon after, the accused Shankar Rajvanshi set fire through his gun, which hit on the right leg of my 4-year-old daughter Durgabala Mandal and also on the stomach of my wife. Having heard hue and cry raised by us, our co-villagers Ramesh Sarkar, Subal Burman, Shambhu Burman, Bidubasi Mandal, Bolendra Burman, Hitish Chandra Mandal, and many others, about 50 people gathered at my residence. At that moment, we could see that my wife received bullet injury on her stomach. Immediately, my elder brother Bidubasi Mandal lodged the Azahar at Bijni PS. That is immediately Azahar, FIR was lodged. Immediately, police came and police took my injured daughter and me with injuries to the Bhetagaon hospital. My wife succumbed to her injuries. Prior to arrival of the police at my residence, considering the gravity of injury of my daughter, Bhetagaon hospital referred my daughter to Guwahati Medical College and Hospital for treatment, where she was admitted for about 17 days. I was admitted at the Bhetagaon hospital for 3 days. The dead body of my wife sent to Dhubri Civil Hospital for postmortem examination. Police recorded my statement after 3 days of occurrence on my arrival at home. Panbari OP stands at a distance of about 4 km from my residence. The distance of Bijni PS from my residence is about 10 km. The residence of Bidubasi Mandal stands at a distance of 200 meters from my residence. In between residence of myself and Bidubasi Mandal, the residence of Ramesh Sarkar, Fakishan Mandal, and Shambhu Burman stands. This Fakishan Mandal is the PW1 lot. My residence was not electrified. I do not know as to the hurricane lamp, the only source of light at the relevant time of occurrence was seized by the police or not, as because soon after the occurrence, I was taken to the hospital. My brother Bidubasi Mandal did not discuss with me as regards the occurrence. Prior to filing of the Azahar, although my elder brother did not ask me about the occurrence, he could know about the taking of the articles listed in the Azahar from my other relative. After disappearance of the miscreants and looking into the incident, I became unconscious. Next time, more or less about half an hour after the entry of the miscreants into my residence, I became senseless. He became senseless after entering of the miscreants, my lord.
So,
Now,
how far? It is half an hour.
Half an hour.
How long were the miscreants in the house? Half an hour.
That is not mentioned, my lord.
It will take just a few minutes.
That is not mentioned. Shankar Rajvanshi, Ranjit Rajvanshi, Gyanendra own black dresses. Their facial portions were open, from which I could identify them. It is not a fact that I did not state about the black wearing papers of accused Shankar Rajvanshi, Ranjit Rajvanshi, and Ganendra before police. It is not a fact that I did not state about the lightning of the hurricane lamp in the residence of the at the time of occurrence. I do not know whether the dagger which I pulled out from the accused Ranjit Rajvanshi was seized by the police or not. It is not a fact that I did not state about receiving bullet injury by my wife at her stomach. I also stated before police that accused Jiten Das, Khushi Mohan Rajvanshi, Ratan Rajvanshi, Majo Rajvanshi were among the group of miscreants who entered into my residence at the relevant time of occurrence. So he did not tell the police about the present appellants. He named these persons only. I also stated before police that accused Jiten Das, Khushi Mohan Rajvanshi, Ratan Rajvanshi, Majo Rajvanshi were among the group of miscreants. So these name of present appellants were not stated before police. It was not fact that I did not state before police in course of investigation that I received injury on my right hand, back, and on my chest. It is not a fact that I did not pull out the dagger from the accused Ranjit Rajvanshi and inflicted dagger injury on the head of accused Ranjit Rajvanshi. Now, my lord, he stated, I regained consciousness in the early morning before taking to the hospital. My brother lost the azhar on the next day morning at about 7 a.m. I narrated the matter to each and everyone whom I could find, that I could identify the miscreants, and that my brother Bidubasi Mandal also heard about the said matter. My brother Bidubasi Mandal lost the azhar after hearing the utterances by me after regaining my sense. So after regaining consciousness, he stated everything to all the people. He stated everything to his elder brother also, and elder brother lost the FIR. Had it been so, my lord, he named the present appellants, elder brother could have named in the FIR.
Come to the medical.
Medical is not exhibited, my lord. That is not there.
And the doctors.
Doctor's evidence who treated them, that doctor was not examined.
No. Page 19.
19, my lord. On 7/7/1989, I was working as medical and health officer at Thubri Civil Hospital. On that day, he conducted a postmortem.
That's what.
He conducted a postmortem. On that day, I did the postmortem examination on the dead body of Dandabala Roy, female Hindu, 24 years of age, of village Lokhijora, PS Bizni, and the dead body was escorted by WBC 420 so-and-so and Homeguard so-and-so, and in connection with Bizni PS case number such and such. During postmortem examination, I found the following. Shorty female body rigor mortis present, eyes and mouth were closed. A sharp penetrating injury is found on the left iliac region, 4-inch deep, 1/2 inch size, and mild ileum is seen on the wound with multiple punctures on the ileum. Antemortem blood clots seen, no other injury seen. Stomach contains semi-digested food matter and other organs were healthy, and all injuries described are mortem in nature, antemortem in nature. In my opinion, the cause of death is shock and hemorrhage as a result of stab death on the abdomen wall. Exhibit 2 is the postmortem report. Time taken for food semi-digestion requires 2 hours. I have not found any stitching mark on the wound position of the deceased. I cannot remember who accompanied person of the dead body shown in any weapon or not. Exhibit 2, I have not mentioned the age of the injuries. So, the wife of PW2, she succumbed to injury. I am not on that. I am on whether the present appellants had any involvement. They were not named in the FIR. Now, my lord, this who is presumed as eyewitness.
Yeah, I think you're concentrating on the wrong side. I mean, you should concentrate on the bullet. Where's the bullet?
That is also not mentioned in the postmortem report.
You concentrate on
Yes,
that.
my lord. That is not mentioned in the postmortem
That
report.
is where I'm
And no weapon was seized.
There is no bullet wound, madam. All
On
the
the-
medical evidence does not indicate any bullet wound. No evidence of PW2 says that he said to his gun which hit on the right leg of my 4-year-old daughter and also on the stomach of my wife. So there's no bullet wound anywhere.
But there are other injuries and this PWT two is also
Bullet wound,
knees, my lord.
this postmortem report is silent. Evidence of doctor is completely silent. There is no recovery of any bullet. Anyway, we carry on. Anyway, just 5 minutes.
Well,
Just sitting too long, back hurt, starting to hurt. You just look at that aspect. Carry on.
so my lord, one thing is that although he is presumed as eyewitness, but what he told after getting consciousness to the people and to his elder brother and hearing him, he has lost the FIR. It is his evidence. But in the FIR, nobody was named. That is one thing. The PW1, who came first? He came first. And he heard the name of another two, but these two were not named. That is one thing. And in postmortem report, although it is bullet injury was mentioned in the evidence of PW2, but in postmortem, that is not there, neither bullet injury nor stabbing, nothing is mentioned in the postmortem report. And no weapon was seized.
No, stabbing is there. In the post-mortem, there is there. It is,
A sharp penetrating injuries,
a sharp penetrating injury will be what?
but no weapon was seized, my lord. And a trial court has presumed PW2 as eyewitness, sole eyewitness. But his evidence,
Look, in my opinion, the cause of death is shock and hemorrhage as a result of stab death.
yes, my lord, that is-
It is stabbing.
bullet is not there. Bullet is not mentioned, stabbing is there. But no weapon was seized by police. And my lord, the FIR was lodged immediately after the occurrence. At 1:32 AM, occurrence took place. After getting consciousness, PW2 stated everything to the people. His elder brother was also there, and he has himself has admitted that after he has stated everything to Bidubasi Mandal, and on the basis of that, Bidubasi Mandal lost the FIR. But in FIR, he has not named anyone. Some unknown miscreants. And unfortunately, he expired prior to recording evidence. But PW1, who is also his own brother, he stated in his evidence that PW2 did not tell that he recognized the people. PW1 at page 11, it is not a fact that my younger brothers recognized the accused person. And so he told me their names. So immediately after the occurrence, he came. First person is the PW1, Hokirichan Mandal, he came, then others. And PW2 did not recognize these people. And then informant Bidubasi Mandal came and others came, and PW2 in his evidence has stated at page 15, I regained consciousness in the early morning before taking to the hospital. My brother lost the Ejahar on the next day morning at about 7 AM. I narrated the matter to each and everyone whom I could find, that I could identify the miscreants, and that my brother Bidubasi Mandal also heard about the said matter. My brother Bidubasi Mandal lost the Ejahar after hearing the utterances by me after regaining my senses. If that be so, my lord, Bidubasi Mandal in the FIR could name the people if someone was named by PW2. My lord, in 313 statement, The appellants have denied all these things, but learned trial court at paragraph 30, my lord, page 72.
Yes.
Paragraph 30, page 72, when a trial court has held, so far as the involvement of accused persons are concerned, it appears that entire case is basically based upon the evidence of PW2, PW1 and PW3. The PW2 is found to be the sole eyewitness of the incident. As such, the case is based upon the evidence of sole eyewitness. He is the sole eyewitness. That is correct. But what he has stated in his evidence, that after regaining, he uttered all these things to all the people who gathered, and he stated all these things to Bidubasi Mondal also, his elder brother. And on the basis of his statement, Bidubasi Mondal lost the FIR. Had he named the present appellant, and immediately FIR was lost, so they could be named in the FIR. And PW1 Phokirishan Mondal also stated that PW2 did not utter all this. And he was the first person to come. And it was in the night. And again, we look at page 74, the paragraph 35. The trial court has stated that accused number 2, appellant 1, he has indirectly admitted. But I will show that statement, my lord. If the evidence of PW2 along with the statement of A2 is considered together, it appears that PW2 dealt a dagger blow on the head of A2 and who categorically admitted the fact that he sustained cut injuries on the head due to the dagger blow dealt by the PW2 on his head at the time of incident. Further, the injuries sustained by the A2 on his head was fresh and hence police immediately after his arrest provided treatment at Bhatagao Hospital. Therefore, the evidence of PW2 is indirectly supported by statement of A2. Now, my lord, this 313 statement of A2, Ranjit Rajbangshi, it is at page 33, my lord. The specific question was put on him regarding this at question number 8, page 35. PW2 also stated that sustaining on such merciless condition, he put resistance against the accused persons and pulled out the dagger from the possession of accused Ranjit Rajbangshi and dealt a dagger blow on the head of the accused Ranjit Rajbangshi. But replying to this, he has that it is false. But the trial court presumed that appellant number 2 admitted that. But there is no admission. He denied that. It is at page 35, the question.
No, where in the judgment, where does it say?
Judgment, my lord, it is paragraph 35. Paragraph 35, 74 page. Page 74 of the paper, my lord. Paragraph 35. If the evidence of PW2 along with the statement of A2 is considered together, it appears that the PW2 dealt a dagger blow on the head of A2 and who categorically admitted the fact that he sustained cut injuries on the head due to the dagger blow dealt by the PW2 on his head at the time of incident. So, no whisper at all, my lord. Replying to that question, he has denied it. Question number 8.
What else?
And my lord, the trial court has relied upon one judgment. It is 2020 4 SCC, page 33, is Parbat Singh and others. The paragraph 12 has been relied upon in the judgment. But it says, my lord, sole eyewitness can be taken into account. That is exactly, my lord. But the quality of the witness. Paragraph 12 has been relied. Paragraph 12. At the outset, it is required to noted that appellants here in original accused 2 to 5 are convicted by the learned trial court and the High Court solely relying upon the evidence deposition of PW8 so and so. It cannot be disputed that there can be a conviction relying upon the evidence deposition of the sole witness. However, at the same time, the evidence deposition of the sole witness can be relied upon provided it is found to be trustworthy and reliable and there are no material contradictions and or omissions and or improvements in the case of the prosecution. So Lord, here the eyewitness which presented as eyewitness, PW2, his evidence, what he stated that after gaining his consciousness, he stated everything to the people gathered there. And where his elder brother was there and hearing all these things, he has lost the FIR. So my humble submission was that in FIR, it was immediately lost after the occurrence. And the PW2, who is presumed the sole eyewitness, he did not utter the name of present appellants before the informant who has lost the FIR, and he has stated that on hearing his statement, he has lost the FIR. And PW1, who came first, whom he told everything, he did not name the present appellant. In postmortem report, there is nothing regarding bullet injury. No weapon was seized. So, Lord, benefit of doubt is in favor of the present appellant.
Anything else?
That's all.
Lordship is taking up the main appeal or the IAM?
Main appeal, everything.
Lordship is taking up on merit, my lord. Then your lordship may kindly have a look at evidence of PW2, whether his evidence is believable or not. Vis-a-vis, he has named specifically the applicants as well as other accused persons, my lord. Lordship, apart from that, your lordship is lordship observed there's a bullet was not seized, whether it's fatal to the prosecution. But as per the postmortem report, your lordship will kindly see in the postmortem report, my lord, page 94, 90. '91.
Yes.
Wound's position and character. A sharp penetrating injury is found on the left iliac region, 4 into deep, half and half inch size. Mid ilium is seen on the wound with multiple punctures on the ilium.
Where is
So
the-
punctured wound,
Where is the ilium?
ilium is on the stomach. I'll have to see. So it's even the eyewitness same, I know, it was on the this one, on the stomach. It might not be specific, your lordship, but it was on that part, your lordship. So how can he be disbelievable, my lord? And your lordship, apart from that,
For that, you come to para 54
of the
of the paper book, page 82. Page 82. Please read.
yes, in an instant case from a medical report of Dr. N.N. Das, that a minor daughter of the deceased sustained bullet injury, the PW2 saw that the A1 shoot bullet from his gun, and a doctor who conducted postmortem on the dead body also noticed certain punctures, which generally causes due to bullet injuries. The use of gun by the A1 is duly established with unimpeachable ocular testimony and which is supported by medical evidence. Therefore, non-recovery weapon is according to my submission, it's correct, my lord.
Now, the issue is, where does the Dr. N.N. Das come into the picture? How does he come into the picture? Medical report of Dr. N.N.
N.N. Das.
It is not exhibited. His evidence is not taken.
Oh, your lordship may kindly see the doctor who seen the injured persons. It's a part of the charge sheet, my lord. Kindly have a look. Page 99. Part of charge sheet it was. I don't know how come it didn't come on record, my lord. Page 99, last portion. Two medical reports of the informant and the accused in the postmortem examination report have been enclosed here. It was a part of the charge sheet, might be on the record, my lord. I don't know why it was not enclosed because everything the investigating authority has to forward to the court concerned.
So just look at the report. Because this NN Das report and his evidence is not there.
This evidence is not there, but whether his document is there or not.
Whether it has been exhibited.
Yes, because it was a charge, since the charge sheet has been exhibited, it was a part of the charge sheet, my lord. And closes of charge sheet, my lord. It was a part of the charge sheet. I examined the following injured person in the 30-bedded rural hospital, Bizni, Bhatgaon. It's by NN Das, Ranjit Rajbongsi, name of the injured person. Lacerated wound on the scalp. The injury is simple in nature and is seemed to be caused by blunt weapon. Then and I examined following injured persons in the 30-bedded rural hospital, Bizni. Nature of injuries, it was a Sahadev and Durga Mondal. Sahadev Mondal lacerated wound on the left palm, lacerated wound on the middle finger, lacerated wound on the back scapular region, lacerated wound on the right knee joint. The injury is grievous in nature and is seen to be caused by gunshot. It was a part of the charge sheet, my lord.
Maybe part of the charge sheet, but then where is the exhibit of those documents?
No, charge sheet was exhibited, your lordship.
Sheet may be, but charge sheet is relying upon some medical report.
Yes.
Then under
But
the medical report.
concerned, my lord, it's a lapse on the part of the investigating agency as well as the lordship trial court, my lord. But while the matter is before this honorable court, your lordship, and since injured eyewitnesses account is there, my lord, whether your lordship will overlook that, my lord.
Well, we see here, the medical evidence cannot be given a go by because that is what the trial court has relied upon.
My lord.
That the para 54 provides that that there was a bullet injury in terms of the medical report of Dr. NN Das. So where is-
Reflected.
where? And it was this NN Das, Dr. NN Das, was he among the prosecutors? Is he in the list of prosecution witnesses?
My lord. Yes.
And why was he not examined?
Lordship, there's an order dated 12/2014 of the learned trial court, which says accused so and so are present, accused so and so are present. Then till the summon upon Dr. NN Das and Dr. K. Deka could not be served, as some of the joint director of health services of various districts have reported that there is no much doctor. This is a very old pending case, and examination of the doctor is very much essential for just decisions of the case. Due to non-availability of present posting or present address of Dr. N. Deka, MNH Civil Hospital, Dhubri, and Dr. N. Das, who worked as Senior Medical and Health Officer at 30-bedded Rural Hospital, Bisni, on 27/9/90. Summon could not be served as such Under Secretary to the Government of Assam Health and Family Welfare Department, Guwahati is directed to furnish present address either official or residential of aforementioned doctors, send copy so and so. And no report has been received yet.
There seems to be some missing links. There
In the
seems
sense
to be
of-
some missing links. In this, in the prosecution case. What we'll do is we'll dispose of the IA.
Yes.
We can help it. We'll,
Will the matter be taken up for hearing, Your Lordship? Because
Yes.
paper book has been received by me.
but in the meantime, we'll dispose of the IA.
Lordship may not allow it because, my lord,
yeah.
eyewitnesses account is there, my lord.
There are some missing links, madam.
They were on bail during trial, right?
They were
But I don't know.
all along on bail.
I think we'll allow this. You pass the order, small order. Huh? Correct. Yeah, you don't have to do that. No. So IA is disposed of, huh? Appeal allowed, IA is allowed. Bail bond of rupees, how much? Madam, how much?
50,000?
50,000, with one surety of life.
There are four villages, my lord.
You don't have
There's satisfaction of
deposit the money.
district session judge,
Session judge.
Sirang. Sirang at Kajalgaon.
No. Then in the main case, you're right. In the main case here, list the matter for hearing after a month.
Machu. There are two applicants, two applicants.
Both of them.
Machu.
Yeah, please.
May please, Your Lordship. Lordship, we filed this 430 application against the judgment and order dated 30/4/2025, Lordship.
Yes, so written objection file.
Yes, Lordship. Objection has been filed.
Yes, so you want to have a hearing on the 430 or what?
Yes, Lordship. I.
facts of the case is that on 01/10/2018 at around 5:45 PM, in the judgment, it is written 4:45 PM, which is not correct. It is 5:45 PM as per FIR. A telephonic information was received from the wife that one quarrel has started in the rented house at Salakati Bazaar among our tenant S. Alam. Then again, one Sikandar Kumar and another person. And when we immediately reached the place of occurrence, we found a dead body of one Muhammad Shakil, the victim, who was of 42 years of age, and they were from Bihar and they were inside the room campus. Then the landlord immediately informed the matter to the police. That is the FIR, Lordship. 3 persons were arrested and the FIR was given by the landlord. Now, in this case, Lordship, 17 prosecution witnesses were examined and the whole conviction is based on circumstantial evidence and on the basis of the last seen together, Lordship. Theory of last seen together. Now, coming to the prosecution witnesses, Lordship, which is on page 64, PW1, Lordship. There are no eyewitnesses in this case, nothing, only hearsay evidence, Lordship. So, PW1, Lordship, the informant A. Brahmo is my maternal uncle. I know the accused person. The incident occurred at our residence. We have tenants in our house. The accused persons are our tenants. At about 5:30 PM, my elder brother D. Bosumatari called me in the room of the accused person where I saw the dead body and blood coming out from the stomach region. The accused persons wanted to flee, but myself along with Rithun apprehended the accused persons. Thereafter, police was informed and they had come to the place of occurrence and took the dead body along with them. My statement was recorded by police. Now, in the cross-examination, I do not live in the house where the occurrence took place. I do not know how and in what manner the offense was committed. I am not sure whether the accused persons are tenants or not. By the time I reached the place of occurrence, darkness had crept in. This is the PW1. Second, PW2, he says that the informant is known to me. I also know the accused persons. The incident occurred about 4 or 5 months back at about 5 to 5:30 PM. D. Bosumatari called me to his residence. I saw the dead body of a person on the floor of a room and blood spilled around him. I saw the accused person standing outside the room and the accused persons wanted to flee from the area, but we apprehended them and informed police. Police came at the place of occurrence and took the dead body and the accused persons. Now in his cross, I do not live in the house where the occurrence took place. At the time I reached the place of occurrence, darkness had crept in. I have only seen the dead body. I have not seen anything else. I do not know how the occurrence took place. It is not a fact that I have not stated before the police that the accused managed to flee from the place of occurrence. Now, 2 witnesses claim that they tried to flee. No other witnesses state this thing that the accused appellants tried to flee. Moreover, these 2 PWs, whatever they have stated now is an afterthought because in their 161 statement, they have not stated that these accused appellants tried to flee from the place of occurrence. Now coming to PW3, I know the informant. I also know the accused person. The occurrence took place in the month of October 2018 at night hours. I was in Salakati Bodosa Land Club at the time of,
Tell me,
Yes.
there were how many tenants? 4 tenants.
There are 4 rooms, Lordship. Out of 4 rooms, one of the rooms was rented by 4 persons. Out of the 4 persons, 1 person died, Lordship.
So the 3 of you all are left.
Yes,
So all 3 of you all are convicted.
yes, Lordship.
So then you will know what happened within the confines of the 4 walls of your room.
Lordship, that is the problem, Lordship. The problem is the whole thing, Lordship, whether there is a recovery of a weapon
which has not been sent to
Did he die?
FSL.
How did he die? Some stab wound?
Yes, once homicidal stab wound, Lordship.
Stab wound.
Yes, Lordship.
Did he stab himself?
Lordship, he was in a habituate, Lordship. There are witnesses
He was in-
state, Lordship, there are witnesses which state that he was in a habit of drinking alcohol
So?
and he used to self-harm himself.
Huh?
He used to self-inflict harm upon himself, Lordship.
Sit down.
Yes.
Who
There are
said that?
witnesses which state that.
Who said that?
Yes. Moreover, Lordship, the murder weapon was not sent for FSL, neither there was any
How many
fingerprint.
stab wounds has he got?
Only one, Lordship.
Where?
In his abdomen, Lordship.
So he stabbed himself.
Lordship, that may be an alternate theory.
Which of the prosecution witness had said that he has a habit of self-inflicting?
Lordship, Lordship, it is PW9, Lordship. Page 73, PW9. I know the accused person. The deceased Shakil is my relative. He had come to Salakati along with the accused persons in search of job. The accused person and Shakil used to live in one room. After a few days, I came to know that Shakil had died. I came to Salakati and after post-mortem, police handed over the dead body of Shakil to us. In his cross, he says Shakil was a habituated drinker of alcohol. He was in the habit of causing injuries to himself in inebriated condition. I personally do not know what circumstances Shakil died. This is one of the statements.
Page?
That is on page 73, PW9, Lordship.
Was he in an intoxicant state on that date?
Lordship,
What revealed to the
he was in an intoxicated state, but that
PM
cannot be
Visara
known
again?
because his viscera was never given for examination.
PM consent.
Yes, PM is
Space?
PM in PW12, page 76.
No, PM report to enclose.
PM report to enclose corner जाते हैं already in PW के reference पर. If Lordship may come to page 85, Lordship.
You see, he has a habit of causing injuries to himself means what? He's to stab himself or something, or go for a death-defying jump from a 3-story building, 4-story building, or what?
Lordship self-harming
How?
himself.
How self-harming?
That Lordship,
He's to stretch his neck
that is
once in
Lordship,
a while or what?
that is open to interpretation.
It was of homicidal nature. It was not like
But-
suicidal.
But only on the basis of a
That's neither
PM
here nor
report,
there, no?
Lordship.
It's only a,
conviction cannot be given. Lordship, kindly come to page.
no, you see, one thing is that at the time of his death, you all three were there, correct?
Lordship, not only we three were there, there are other people in the house also.
Other people, but you were in the room with him.
Not room, Lordship, outside. Because PW14, Lordship, if kindly come to
Right
PW14.
outside.
Yes, outside there was a quarrel.
Outside there was a
Yes, Lordship. From there, the conviction has occurred that last seen together only on the sole basis of that.
Let us see
The
the
con-
medical report.
Yes.
He has not enclosed it. Evidence of PW12 is there.
No, we have to see the medical, what type of injuries and everything.
Lordship, that has been exhibited in by PW12 in page 76.
Stab injury seen over the left side of abdomen.
4 inch into 1 inch with herniation of abdominal fat and oozing of blood.
Whether in 313, whether they have discharged their burden, your lordship. Lordship has to see because they were inside one room, my lord.
Lordship may come to the the deposition of the IO Lordship, which is on page 85.
I think, let them read the paperwork.
Yes.
Lordship, last Lordship, only page 85 Lordship, which is the examination, which is the deposition of the IO Lordship.
No, let them read the paperwork.
Lordship, there has been no examination of the murder weapon. Nothing has been sent. Only on the basis of Lordship. Prima facie Lordship, there is a no case.
As the trial court records have arrived, I registered to prepare the paperwork. This is the matter of the police.
Lordship will be shocked to see this doctor who conducted autopsy is not expert in this one forensic autopsy. I'm an MBBS with diploma in ophthalmology.
Moreover, Lordship, murder weapon was also not sent for any. Only on the basis of last scene. Obliged, Lordship.
Please, your worship. My lord, the IA is filed for granting bail to the.
May it please, your lordship. I was directed to obtain instructions on the additional affidavit filed by the petitioner, copy of which I received on the 21st, my lord. If I may please be granted. It's an affidavit for completing the lordships.
Now, please stop. In the meantime, we have passed it on the side of taken and safety is beginning of the meeting. Yes, no petition, the writ petition, writ appellant. You see, just give me the main appeal.
Lordship, Mr. R. Sharma will be appearing in this matter.
Where is he?
Lordship, he had to leave the court for some personal urgency, Lordship. Let it be fixed on another hearing day
I will fix it tomorrow.
tomorrow.
You see, there is one thing.
Yes, Lordship.
He had applied for the post of office, correct?
Yes, Lordship.
He could not secure the minimum cutoff mark for the written test.
Lordship.
Now, during the proceeding and during the hearing, it has come to the knowledge of the court, selections have been made. And in fact, one person had been appointed. Now, the single bench has said that as there is no challenge to the appointment of the person who had been duly appointed, then the decision on merit without hearing the person affected to be affected would be in violation of the principle of natural justice. So they set aside the order. Now, what is wrong with the order?
Lordship, he was selected during the pendency of the writ petition, earlier writ petition, Lordship.
Yes, correct.
Yes,
There was no say. Now, what is wrong with the order? What can be done is you file a fresh writ petition challenging that person's selection and eventual appointment. Not by way of this writ appeal. There's nothing wrong.
Let the matter come up day after tomorrow.
No, they have to tomorrow, on the prayer of the petitioner, on the prayer of the applicant's counsel, let the matter tomorrow.
Not tomorrow, Lordship, day after tomorrow.
Tomorrow,
Day after tomorrow, Lordship, kindly, Lordship.
tomorrow. You don't come with discussing it tomorrow.
So we have filed this for an early date of hearing, Lordship, I have early date of hearing.
Lordship, we have no any objection, any date will be fixed for hearing.
Second week of September, Lordship, any date.
October?
September, Lordship, second week, Lordship. We are not getting our allowances, Lordship, despite an writ petition, a judgment and order in our favor.
I think if they, let it go before the DB1 matter, so let it be listed on Friday. This is the matter on Friday.
Lordship. The IA, Lordship.
Huh?
The IA, Lordship.
Let it,
Lordship.
you should put this, acknowledgement.
So this is having a second time, Lordship, because on the last time, Lordship, I am not able to present before the court, Lordship. Due to non-appearance, Lordship, it was dismissed, Lordship.
Mr. Counsel, this IA, would it be maintainable? Unless the earlier order is recalled. We come to page 55. And the relevant portion is at page 61. You see, your earlier IA of 2191, the prayer is the same as this IA. You are asking for treatment as respondent number 77.
Yes, Lordship.
Now that early IA has been dismissed for non-prosecution. Now you are coming here with a different IA with the same prayer.
No, Lordship, there is thing, Lordship, that time no appearance was there, Lordship, and there is no, it's a reflect on the order, Lordship. Since nobody came forward to praise the application, we deem it appropriate to dismiss it for the non-prosecution.
Correct.
Lordship.
So what is wrong with the order? So now, you see, you cannot file one order after the other. This order as on date is final. What you can do is you can ask for recalling of this order. Not by way of you file an application to recall this order dated 37/25 passed in IA Civil 2191 of 2020. Okay, this is the way. You cannot file a separate application with the same prayer as the earlier order has already taken care of this application. So you withdraw this application with a prayer to file a separate application for recalling of this order dismissing your earlier application. That's all. Okay, this is not the proper way. Mr.
And Dubey, Lordship.
L. Dubey, learned counsel for the applicant, submit that he may be allowed to withdraw the present application, with liberty to file an application to recall the earlier order dated 30/07/2025, passed in IA Civil 2191 of 2020. Mr. H.K. Das.
But I am appearing as an amicus milord in the PIL.
Appears for the amicus
In the PIL. PIL petition.
Ms. Sharma appears for 1 to 52. The prayer of the applicant's counsel is allowed. I is accordingly withdrawn. Dismissal is withdrawn, with liberty of faith.
oblige.
Highly.
Where's your lordship? My lord, this appeal is directed, my lord. My lord, against an order.
Should we issue notice?
Yes, my lord. I is by way of abundant caution, not by.
I know, but the thing is that there are other respondents here.
My lord.
Right.
Notice.
Heard Mr. T. Chaudhary, learned counsel for the applicant, who submits that there is a delay of 1, 2, 4, 3 days in filing the present application. Issue notice returnable in 4 weeks. Mr. R.K.D. Chaudhary, Deputy LGR, appears on behalf of
Respondent number 2. I'm sorry. 1. What? 100?
on behalf of
He has given me 2 copies of writ appeal. I do not buy.
2. Appears on behalf of 2.
2, my lord.
2. You have got nothing to say, I think.
No, I think the court has passed an order to the petitioners to file a representation, and it was disposed of on the day of motion. And his representation was disposed of. His grievance is that he was not.
No, it's not only that, my lord. It's not only that, there are other things, my lord.
The writ petitioner has died.
My lord. Yes, my lord. He died. He expired, my lord.
And he did not know anything about.
My lord.
It's a question of money.
No, my lord.
Huh?
No, my lord. Why, my lord, it's a question of a arms license, my lord, a arms manufacturing license. That was, my lord, transferred to this appellate, my lord, by his father during his lifetime. And there was a number of litigations, my lord, as to whether that was valid or not, my lord. And, my lord, the court directed that there an inquiry has to be made. And on the basis of the direction, my lord.
Who's for the state? State government?
My lord.
We call the state government, otherwise we'll have to issue notice. We will accept. Commissioner Police and
My lordship may issue notice, I'll hand over copies, extra copies to them, my lord.
then applicant to take steps for service of notice upon the private respondents 1.1 to 1.5 by registered post with AD within 2 days.
My lord.
List the matter on, give it. They just write one thing, Mr. So accept notice on their respondents number 3 and 4, huh?
My
Then we'll put their name later.
lord.
Just find out who is taking.
My lord. नाम तो मैं कोडिंग मत लो.
Lordship, the conducting counsel, Mr. Adhor, he is on legs. So I pay for Passover for timing.
Third, Mr.
D देखा.
D. Dekha. Yes. Learned counsel for the petitioner. Justice B.D. Agarwal. And Mr. R.K.D. Chaudhary. Learned Deputy SGI. Appearing for
1 to 5, Lordship, 6 will be by the state government.
1 to 5. No one appears for the state. Yes, sir. The petition has filed this public interest litigation, praying for a direction to be issued to the respondent authority to modify slash alter slash amend the rules slash guidelines in relation to disclosing the original place of birth of adopted children while issuing passports and birth certificates or any other certificate, as it violates, as it allegedly violates and infringes upon the right of privacy of the said person. Is there any ruling that what right of privacy?
Also, will kindly come to page 11 of the PIL that we have quoted a provision of regulation of adoption which talks about the confidentiality. So that is the basis of what we have SL in page
Page
11.
11.
We have quoted the provision also.
Says except as permitted under any.
As there is no rules or law which says it should be masked or kept in secrecy. That's why we have SL in PIL.
All agencies or authorities involved in the adoption shall ensure that confidential adoption because maintained. They say that, so what is wrong?
As what we came on the basis of that, if the information of the parents can be kept in records.
Information of parents are kept is not going to be in the passport.
Lordship. So what we are trying to see if in that analogy, if the name of the parents can be masked out or it can be kept on records, not on the passport, what will be the difficulty in maintaining the record of original place of birth of any adopted child in the similar fashion, keeping on record by the.
But how can you say that? Like I said, what about a 10-year-old child who is going to school?
Lordship, that of course has come up.
Then
but
how are you going to take care of that issue?
Of course, that has just fallen from your lordship. Well, course of
we are looking at only 1-year-old, 2-year-old babies, no?
Lordship, that probably would have been the guiding.
Yes, that would have taken that when but you have got to consider all those issues, right? The petitioner's counsel submits. As per Regulation 45 of the Adoption Regulation of 2017. The authorities and agencies involved in the process of adoption must maintain confidentiality of adoption records, except as permitted under any other law for the time being enforced. And for such purposes, the adoption court the adoption court order may be displayed in any public forum. He also submits that as per Regulation 1210 of the Adoption Regulation of 2017, the specialized adoption agency is to carry out the necessary act of birth certificate, the necessary act of issuance of birth certificate in cases of adopted children post-adoption order by the court. So under this sub-regulation, the specialized adoption agency has been directed not to disclose the names of biological parents and instead endorse the name of only adoptive parents in the birth certificate. As the regulations have tried to uphold the confidentiality of the adopted child by requiring not to disclose the names of the biological parents, the place of birth of an adopted child should not be put in the passports/birth certificates of the adopted child. That's your case.
Also, that would be. And also they have made special provision in case of certain like single parent and all other aspects of while case of adoption is concerned.
He also submits that in the case of an adopted child, there was no need for an advent mother to disclose the identity of the child's father in the birth certificate.
Even a single parent can adopt and there is no necessity.
As she can be the sole legal guardian of the child. In terms of ABC versus State bracket MCT of Delhi, 2015, 10 SCC 1. Correct?
Actually, I'll not be decided. 15-1. Write it down.
It's in the order anyway. It's going to be in the order anyway. No need to write. Next paragraph. Mr. R.K.D. Chaudhary, the learned Deputy SGI, on the other hand, submits that
Lordship, let's see page 104, Lordship, my in the affidavit. But not registered and name of parents known.
Submits that in terms of the circular number 1/7/2011 -VS bracket CRS dated 12/3/2012 issued by the Registrar General India issued by the Office of the Registrar General, Ministry of Home Affairs, Government of India. In case an adopted child has not been registered under the ambit of the Registration of Births and Deaths bracket RBD bracket close Act 1969, the place where the adoption agency is located shall be treated as the place of birth of the child. In the event of the date of birth of the child being not known, the same as determined by the Chief Medical Officer or any duly licensed physician, and as reflected in the adoption order/deed issued by the local magistrate, shall be recorded as the date of birth of the child in birth recording form. Besides the date of birth, the names of the adoptive parents and address of adoptive parents as contained in the adoption order deed along with the number and date of the order shall be entered in the birth reporting form. Full stop. The names of parents shall also be entered in the birth reporting form.
So this takes care of the place.
Full stop. He submits that in case the birth of the adopted child has not been registered, no, he submits that. It is only when the date of birth of the adopted child has already been recorded that the above circular would not be applicable, would not be made applicable. Correct? Good stuff. He submits that the place of birth and date of birth as mentioned in the original birth certificate will not undergo any change and shall remain as it is, unless the same has not been recorded. Earlier.
Lordship, I also like to draw your lordship's attention to page 107, paragraph 3. The term adoptive parents, this will not be there in the birth certificate. Lordship. 3A.
He has also referred to para 3 bracket A of the above circular dated 12/3/2012, wherein it has been stated that the term adoptive parents or adopted child shall not be used in the birth certificate. Full stop. The name of the adoptive parents shall appear as parent, bracket father and mother of the child, bracket close, in the birth certificate. The address of the adoptive parent shall be recorded as address of parent at the time of birth of the child in the birth certificate. Next one. He accordingly submits that there are many instances across the country in which place the occurrence of birth of a child is different from the place of residence or state of the parent. This may be due to several reasons, and the argument made by the petitioner that mentioning the place of birth of the adopted child in the birth certificate in a place different from that of the adopted parent will establish that the child is adopted is not correct. Correct?
No, sure.
We have heard the learned counsel for the part. Okay. The perusal of para 7 of the writ petition will mention this. Shows the reason why the present PIL has been filed. Wherein it states that the petitioner had recently seen a passport issued to an adopted child, who had been legally adopted by following all norms and provisions as mandated by the authority. However, in the said passport, the petitioner was appalled to see that while the adoptive parents from the state, while the adoptive parents were from the state of Assam, and their names had been endorsed as parents in the passport, the place of birth of the child showed a different state.
Lordship, that would be of the previous PIL. This has been amended. Lordship is holding the previous PIL. The amended one is the one which probably at the top of the file.
Sure.
Just what we see from the amended PIL is paragraph 7 is different.
This 60, this is the same thing.
Because we
No, this is the same. Public interest is litigation 60.
Lordship, there's a bracket. If it's written amended, that would be the one which
Petition has been subsequently amended.
Amended?
Yes,
7 has been amended.
Lordship.
Huh?
There is a amended petition also.
Which is written in the bracket, it's amended.
Amended. Okay, amended here.
That paragraph 7 will not come in. Because originally was only with regard to passports. Now we have amended to include the birth certificate in the subsequent amendments. Also.
We are in paragraph 9, Lordship, basically.
No, para 9. Para 9 of the amended writ petition. Huh? What have I said? Comma. Different state. Comma, amplifying the fact that the child was not from the same state as the child's parents, and that the child was not the biological child of the parent named in the passport. Correct? I am born in Jorhat. My father is born in some border town in Mizoram. My mother is born somewhere else. Just because, so then what? I do not be, so I am adopted. So what logic is this? I am born in Jorhat. Just because I am born in a different state than my father, I am adopted child.
Of course not.
What kind of logic is that? Where were you born?
I'm born in Nalbari.
Nalbari. Yeah. Where was your father born?
Of course, Nalbari only.
Nalbari. Mother?
Mother she's married from other towns. She of course to the other town.
She's born. Of course, she's born where?
Lordship, what we trying to predict is if parents are resident, permanent resident of a place, not as an individual person's husband and wife as parents, Lordship.
Logic
Because
is
if the
that.
Lordship will kindly go back to the
Now-
page where he has referred to, it says that.
Oh,
place-
just because we have, okay, what is the, yes.
Lordship, I've considered to that effect, but however.
What is yes, what is the, what is the, what public interest is affected?
So that we have tried to bring before your Lordship is that if that comes into that, invest the previous year, the underlying principle of adoption, that was what we are assailing, Lordship. We're bringing before your Lordship. However, if Lordship goes against, I've submitted, I'll concede to that effect. However, the logic was, Lordship, if the parents, as a parent, if they are permanent resident of a state and they adopt from another state, there may be an issue which might crop up, which was,
No.
which we have placed before your Lordship.
You cannot explain everything in the world. You cannot explain. Some things are beyond logic.
Lordship.
Okay. Now you will say that, okay, poor people, they do not move. So poor people, their children will always be the same, but rich people, since they go traveling all around the world, and government servants, their children will be born here, there, everywhere. But even poor people, they move around. They go for, say, a person from Bihar will go to Maharashtra to work.
Lordship.
Person from Kerala will work in the northeastern state.
Lordship.
And from here you'll go to Bangalore.
Yes.
Then what? Where's the logic?
Lordship.
Poor people, rich people, they can all move. Maybe they'll move less, the poor people, but they'll move anyway. Some poor people might move from Nalbari to Dibrugarh.
Yes, Lordship.
Or to Tezpur. Then why limit yourself to a state? Why not to district? Why not to a locality then? If you are living in Kailipara, you have to be living, parents, everyone has to be born in Kailipara.
That should not be.
How can it be? Logic is, you cannot solve everything there. Whatever I say. First stop. I don't remember now what this is way of cut, no? Okay, he filed. Okay. The reason for given by the petitioner for the for filing the present PIL has not taken into account the fact that the children of many couples are born not only in different states, but in different countries, and maybe even in different districts of a state. Though it can be argued that poor people do not move as much as the rich people or government servants, the fact remains that even poor people move around looking for jobs in other states. As such, a poor person who has gone looking for a job in another state may have a child born in another state and not in the state in which he was born. On that ground alone, we are hard pressed to find a reason as to whether the reason for filing the present PIL can cover, can be a public interest reason for filing the present PIL. Next paragraph. The prayer of the petitioner for not recording the place of birth of an adopted child in a passport does not, a passport and what else?
The birth certificate. Lordship.
Huh?
The birth certificate.
And birth certificate does not appear to be reasonable inasmuch as a child can be adopted when it is a baby and when it is at the age of 10 and above also. A child who has reached the age of 5, 6 years would definitely be going to school as per the Right to Education Act 2009, wherein his place of birth would already have been recorded in the records of the state government, state authorities, and the school in which he is going. How would the place of birth of the said child thereafter be amended if the said school going child is subsequently adopted? What's that? What else to say? What else to say? Really? Huh? Next paragraph, right. Though the reasons for filing this PIL is laudable, the manner in which the prayer of the petition does not appear to be practicable, as it appears that the petitioner is only thinking of adoption of babies who would not know their place of birth. However, when juxtaposing the same with adopting children above a certain age, adopting school-going children, who may be even 10, 11 years old, it would be unreasonable and impracticable to change their place of birth after they having had a place of birth recorded in the record for the last 10 or 11 years. Next paragraph. In any event, we find the circular, we find we find the procedure for making such changing entries in the birth record for children taken on adoption. We find the procedure slash guidelines for making slash changing entries in the birth record for children taken on adoption, page 104 of the circular dated 12/3/2012, and paragraph 1 and 3A to be quite reasonable and which do not require interference at this stage. We accordingly. Yes,
I'm sorry, my lord, I come late, my lord. I represent the respondent, that's one number 4 and 5.
Okay, Mr.
DK Sharma.
DK Sharma appears for part number 4 and 5. Anything to say?
4 and 5.
Yes, 4 and 5. Anything
I
to say?
support the argument advanced by my last.
Okay.
Okay.
The PIL accordingly close.
Yes. Blylord.
I think it's all right.
Yes,
It is all right.
Blylord.
As per serial.
I think I did 29 and 30.